welcome all honorable members of the standing committee and the support staff that are also part of this meeting. And also the viewers, I'm told this meeting is live streamed. We can also welcome the viewers. This is our second meeting as the Standing Committee on Petition. And for sure, we remember that in our last meeting, the committee has requested some document to be circulated. They have been circulated to all our members through emails and the WhatsApp group that we have. And I also want to thank you for creating time out of your busy schedule to also to attend this meeting. It's a very important meeting for us, so that we are able to perform our responsibilities as honorable members of the Standing Committee. Without necessarily wasting time, let's proceed to item number 2, which is roll call. I think the roll call is circulating. Can I then request that if there are apologies that we have received, we deal with that?
Thank you, Chairperson. The apology that we have is from Honorable Lutwal, and then Honorable Spoor will be joining us late. And it's already, okay. No, thank you. And then Honorable Max will be joining us late also. Yes.
And Honorable Max has requested to leave here. You just give an indication when you're just about to leave.
Thank you, Chair. I'll probably come back. I just want to collect something and come back.
I think those are the apologies that we have received. Let's proceed to item number 3, which is the confirmation of the agenda. Honorable members, Honorable Mugawa. In second, Honorable Shivasa. They are just whispering at me that with regard to 5.3, for sure you have realized that we do not have it in our documents. Therefore, we request that it should be sent to us, but that item will then have to be referred back. Let's proceed to item 4, which is the consideration of the minutes of the previous meeting that we held on the 12th of September. I think you had an ample time just to go through those minutes. Can we get an indication of the confirmation or consideration of those minutes? Honorable members.
If maybe they can just flag the minutes and then maybe the coordinator can just go through
You want them to go through them? Because I thought honorable members had an ample time just to go through those minutes. But if that's the feeling of the honorable members, we still take that road. They have been flagged. Let's still go through them page by page. I'm not sure whether it's you that Mala would.
Okay. Oh, the Honorable Member, may I assist?
just go page number 1 and if maybe there's anyone comment. There's no one to comment, then we have.
Let's proceed to page number 2. If there is this Inyala on page 2. I think on page 2 it starts with that confirmation of the agenda. The last is 4.2 is consideration of the of committee plans on page 2. Then page 3 it's correspondence announcements, and the last item which is closure on that page. If you would give any indication if you would want to comment on anything on the page, Honorable Mukonya.
Thank you, Chairman. I've not been part of the meeting, but certain things will not permit me to be in the meeting. On our announcement, that sentence is very confusing. The committee coordinator better don't attend this way for lunch.
It's a spelling error, it should be for lunch.
Yeah, so we can adopt minutes like that.
Can we correct that? At least you are observant, Honorable Member. It should be for lunch, not way for lunch. Page 4, it's anything on page 4. The scriber, can you then move, can we then consider the minutes of the previous meeting, Honorable Members? Honorable Mugawa?
Corrections.
Maybe second, Honorable Chibas. Thank you very much. The minutes have been considered or approved. Then we go to item number 5, which is the business of the day. Can we get a presentation of the briefing on Petitions Act and the relevant statement rules and orders?
Thank you very much, Honorable Chair, and a very good morning to you and to honorable members and to my colleagues. My name is Semi Kwata. I am from Legal Services of the Limpopo Legislature. I will be doing a presentation on the Limpopo Petitions Act. And as I will be doing these presentations, I will also be touching on the relevant standing rules of the legislature that relates to petitions and to committee meetings in general changes. Chairperson, before I start with the presentation, I just want to give just a bit of a background in terms of where we come from with regard to this piece of legislation, and that will also give or touch on several aspects of the law-making process, which I think is also very relevant to you as members of the legislature, because you will be dealing with legislation. So that part of that background, I think, will be important, but it will also share some understanding of where we come from with regard to this act. So this act, Chairperson, was enacted in 2003, but before the Limpopo provincial legislature could enact this legislation, in 2000, the Mpumalanga provincial legislature passed their legislation. This particular bill, it was called the Mpumalanga Petitions Bill. So in terms of the process of lawmaking, after the legislature has passed a bill, that bill must be referred to the Premier for assent, that is for signature, before that bill can then become law. So that is what happened in Mpumalanga. It was referred to the Premier, and the Premier of Mpumalanga at that stage had some constitutional reservations. And then he then referred the bill back to the legislature of Mpumalanga. But basically the reservations that the Premier had was that the provincial legislature does not have the legislative competence to pass that bill. So the legislative competence basically means the powers to enact legislation. So just briefly on that point, maybe I need to just highlight that in terms of the Constitution, provinces do have the powers to enact legislation. We know it's part of their core mandate, and then there are certain areas in respect of which they can pass that legislation. The first one being that it is those matters that the Constitution itself envisages the enactment of legislation by provinces. And then secondly, it is where national legislation assigns powers to provinces, where provinces do not have that legislative competence to pass legislation. So national legislation can assign those powers. And Chairperson, this is not part of the slide, it's just the background information. It is not in the slide. So the third matter in respect of which legislatures can enact legislation is with regard to your matters listed in Schedule 4 and Schedule 5 of the Constitution. So Schedule 4 contains matters of concurrent legislative competence. So these are matters which both national and provinces can enact legislation. And in Schedule 5, we have matters of exclusive provincial legislative competence. So which means only provinces can enact that legislation. So the Premier of Mpumalanga at that stage felt that the provinces do not have the legislative competence to enact the Mpumalanga Petitions Act. So the legislature at that stage contended that it does have that legislative competence, looking at Section 116 of the Constitution, which basically says that the legislature may receive petitions from members of the public. So even if it does not expressly say the provinces may enact legislation, but impliedly it does give provinces the legislative competence to enact legislation dealing with petitions. And the Constitutional Court agreed with the contention of the legislature and held that the Mpumalanga province have that legislative competence. And that bill was then signed into law, and it then became the Mpumalanga Petitions Act. Then that actually then paved a way for us as the Limpopo province to actually enact this legislation, the Limpopo Petitions Act, and other provinces also followed suit to enact their own provincial legislations relating to petitions. So that is just the background, Chairperson, to say that this is a legislation that has been tested by the Constitutional Court, and it was found to be constitutional. So as the Committee on Public Participation and Petitions, we are well within the framework of the Constitution in terms of dealing with petitions. That was just the background, Chairperson. The second slide of my presentation deals with the what I call the point of departures or some parameters. I thought I should include this slide because it will then guide this committee and provide some point of departures or parameters in terms of how we should then, going forward, be dealing with petitions that we will be receiving as a committee. The first item there is that we should have an understanding of what a petition is. The Act itself defines this concept. It defines it as a complaint, a representation, or a submission by the petitioner to the committee. But obviously, when someone submits a petition, he will want to have some kind of relief or some kind of satisfaction in terms of the complaint that he is putting to the committee. The second parameter that I want us to look at Chairperson is that we should have an understanding of what the powers and functions does the legislature have. The legislature operates through its committees, and the powers of the legislature are the powers of the committee. So we should have an understanding as to what powers do we possess, what powers do we have as the legislature in dealing with those particular petitions. We know that our powers are the powers to exercise oversight over the provincial executive, and also to ensure that the provincial executive and provincial organs of state are accountable to legislatures. These are some of the powers of the legislature, other than the lawmaking powers and the facilitation of public participation. The other point that I want us to take cognizance of, Chairperson, is Section 40 of the Constitution, which deals with cooperative government, and it provides that the government consists of the three spheres of government, which is national, provincial, and local. So these are the three spheres of government, and it further goes to say that these three spheres of government are distinctive, interdependent, and interrelated. So they are distinctive, they are spheres of government on their own. And the two principles that I want to highlight there is the principles of cooperative governance, which says that it provides that all spheres of government and all organs of state within each sphere may not assume any power or function except that which is conferred to it by the Constitution. And another important one is that in exercising their powers and performing their functions, they must exercise their powers and perform their functions in a manner that does not encroach on the geographical, functional, or institutional integrity of another sphere of government. I think this is very important that I highlight this, because in considering petitions, Chairperson, we should not be seen to be encroaching on other spheres of government. We should confine ourselves to the powers that we have. We should not be seen to be encroaching on the institutional integrity of another sphere of government. I think this is very important, Chairperson, and I'll give you an example of why I'm saying this is important. And I'll give you an example. More often we receive petitions from members of the public complaining about ESCOM and the provision of electricity. We know that ESCOM is a national institution or a national entity which is established by a national legislation, and it accounts and report to Parliament. So, therefore, we as the provincial legislature cannot then deal with such issues, because we cannot call ESCOM to appear before this committee, because we don't have that jurisdiction. Only national, through its petitions committee, can deal with that particular matter. So I'm just giving an example so that we understand that when we receive petitions, we are able to see whether we have jurisdiction to deal with this petition, or can we then refer it to the relevant body, or can we deal with it in which manner. So that is why I've just prepared this slide, Chairperson, just to give us an understanding of our work going forward. So the next slide deals with the legal framework. Where do we, as this committee, derives our powers? So those powers, Chairperson, are derived from Section 115 of the Constitution, which provides that the legislature or any of its committees may summon any person to appear before it to give evidence on oath or affirmation, or to produce any document that the committee require any person or provincial institution to report to it, compel in terms of provincial legislation or the rules and orders of the legislature any person or institution to comply with the summons or requirement referred to in that paragraph, and to receive petitions, representation or submission from any interested person or institution. So this is where we derive our powers, Chairperson, as the committee, to actually receive petitions and to summon people to appear before us to answer any question or to produce any document. So I must indicate, Chairperson, that Section 56 of the Constitution provides for the same provisions that I've just indicated. That the national, that Parliament also have those powers. The powers to summon, the power to compel, and the power to receive petitions. And similarly, also Section 69, which deals with the NCOP, which is the other house of Parliament. It also have these powers to actually receive petitions. So all these provisions that are also applicable in Parliament, both in the National Assembly and in the NCOP. So which means in Parliament we have a committee dealing with petitions, and similarly in the National Council of Provinces we have a select committee also dealing with petitions. It's important that I highlight this because, Chairperson, there will be petitions that relate to entities in the national sphere of government. And we know that National Council of Provinces, actually it is a representative of provinces. So if as a province we receive petitions that we cannot deal with as a province because they are in relation to a matter of where national has competence, we can use the NCOP to actually resolve those petitions, because then they can call the minister in the national sphere to appear before it to resolve a petition that emanates from us as the provincial legislature. And lastly, what I indicated here, Chairperson, is that we should then view the petition process as a mechanism or as a means of exercising our powers as the legislature, so that we are able to exercise oversight over the executive, and also as a means of us being in a position to ensure that the executive is accountable to us the provincial executive is accountable to us as the legislature. So the petition process must be viewed in that regard. Before I pass this slide, Chairperson, I've underlined in the third bullet there. It says that the legislature and any of its committee may summon any person to appear before it. So, what does any person mean? Does it mean that we can summon any person? Can we summon the president, for instance? Can we summon the MEC in another provincial government to appear before us? So, the word any person should not be taken literally, Chairperson. It should be viewed in the context of the Constitution, and particularly in the context of our oversight powers in terms of the Constitution. So basically what it means is that we can summon any person over whom we have the powers to exercise oversight, and the person to whom we can say account to us as the legislature. It is not just any person. I think I can pass on that one, Chairperson. The next slide. The next slide, Chairperson, deals with just the structure of the Act. That is how the Act is composed. We have the definitions, general principles, and then lastly, there are provisions dealing with accountability or reporting to the legislature, and then the admin staff and the procedure relating to petitions. This is just how the Act is structured. And the next slide deals with the key definitions. There are several definitions in this Act, but for the purpose of this presentation, Chairperson, I've just selected a few. The first one being a petition. I've just indicated in the previous slide what a petition is. The Act defines a petition as either a complaint, a request, a representation, a submission by the petitioner to the committee, and it can take several forms. The first form that it can take is that it can be a single petition. So a single petition is a petition by a single individual to the committee. And the second form is that it may be a collective petition. A collective petition is a petition which is made to the legislature by a group of people or an association. So it will be a collective petition. We have received petitions where a group or a community are complaining about their state of their roads. So that is a collective petition. And then we can also have a multiple petition. A multiple petition is a petition where this can be either a single or a collective multiple petition. So it will happen where a petition, in one petition, we have several issues. They are complaining of several issues. Your roads, they are complaining about water, they are complaining about this, but in a single petition. And then it also deals about, the other definition is that of a petitioner. It says a petitioner is a person acting on his own interest, and a person includes a juristic person. And then it can include a person, a petitioner can include a person acting in the interest of another. That is where in case of a minor, for instance, a minor or a child who wants assistance. And then it can be a person, it can be a member, this one. So this one, what basically means is that it can be a member who is acting in the interest of an association. So this is an association, but the petitioner is not that association, but this person has submitted a petition acting on behalf of and in the interest of an association. A person acting in public interest lastly, a petitioner can be the association itself acting in the interest of its members. And I've just included there, Chairperson, the definition of respondent, which is not in the Act. But I felt that it is important that we understand what a respondent will then be, because for every petition, there must be a respondent. There must be a party against whom the petition is against or relates. So if a petition is about something relating to education, we know that the Department of Education will then be the respondent in this case. And then one issue that we have come across in our dealing with petitions is that we have once received a petition from a member of the legislature, submitted a petition to the legislature. The question is, as the committee, can we deal with that petition? A member of the legislature, either being a member of the petitions committee or not, but submitting a petition to the committee on behalf of someone else. Can we deal with that as a committee? Perhaps maybe that's something to ponder as I'm proceeding with the presentation, and then we can engage afterwards, Chairman. The next slide deals with the general principles of us in considering the petitions. And the first important principle there is that the committee must take steps to facilitate public participation by the public in the process of governance. And when we go to section 118 of the Constitution, it provides that one of the powers and functions of the legislature is to facilitate public involvement in the lawmaking process and other processes of the legislature. And it further go on to say that the legislature and any of its committees must conduct its business in an open manner and hold its meeting in public, but reasonable measures may be taken to regulate public access. In the previous meeting, there was an issue relating to whether the public can be part of our meetings, or can we exclude the public in our meetings. So this is very clear that meetings of the committee ordinarily should be open to the public and the media, unless there is a justifiable reason why they should be excluded. And this will explain that. And then it further on goes to say that the committee may not exclude public, including the media, unless it is reasonable and justifiable. And then we have Rule 34 of our standing rules and orders, which provides that meetings of the committee are open to the public and the media, but the public and the media may be excluded if the committee consider a matter which is private in nature, protected under parliamentary privilege, and it is confidential in terms of legislation. So that is the point that I've made to say that generally meetings of the committee are open to the public, and the public and the media can only be excluded where it is reasonable and justifiable. And then the other principles there, these are not all the principles, I've just picked a few. It says that in conducting its business, the committee must enhance democracy by exercising accountability and transparency, must have utmost respect to the rights of petitioners, and also respect the right of petitioners to submit petition in the official language of their choice. These are just the important principles that I've picked up from the Act, Chairperson, They are not all the principles, but I thought these are the ones important for the purpose of this presentation. So the next slide deals with the establishment of the committee, the composition, and the quorum. So this committee is established in terms of section 3 of the Act, Chairperson. And in terms of rule, now it's Rule 85 of the rules. Rule 85 of the standing rules classify this committee as a standing committee, as opposed to a portfolio committee, Chairperson. And the difference here is that unlike a portfolio committee, which is only overlooking the affairs of a particular portfolio, this committee can actually overlook at all the portfolio committees, be it education, health, whatever portfolio committee, can go into the affairs of each and every committee, not only a specific committee like your portfolio committee on education, which is only focused on the affairs of the portfolio of education. And then I've indicated here that the committee, unlike other committees, it's a creature of statute, which means that it derives its powers from this Act, and it can only exercise its powers and functions in terms of this Act. Only those functions that are conferred to it by this Act and nothing else. Otherwise, any powers that the committee exercises outside this Act will then be ultra vires and will be unlawful. The composition of the committee comprises of members of the legislature as determined by the Rules Committee. And in terms of Rule 39, the chairperson is appointed by the Rules Committee. And in terms of Rule 36, the members of the committee may not be fewer than 5 and may not be more than 10. I'm not sure if Mr. Radimana is this being complied with in terms of the maximum. How many are we? 12. But it's fine, because in terms of Rule 36, it says that unless the House decides otherwise. So which means in this case, it can be done in terms of a resolution of the House to extend the members of the committee to 12. It's not a train smash. And then the quorum requirement. This is regulated in terms of Rule 40. It says that the majority of members constitute a quorum. A quorum is important because it is relevant to the question of whether the committee can decide on a matter or not, and it could only decide if the quorum is present. For instance, if the committee is adjudicating a petition, and during the adjudication of that petition, there must be a resolution of the committee. So a resolution cannot be taken if at that stage members of the committee do not constitute a quorum. I think that is very important, Chairperson, so that we know that our resolutions are properly made. But also importantly, it says that the business at a meeting of committee may be proceeded with irrespective of the number of members present. So which means that even if there are 2 members in an adjudication meeting, they can still proceed with the adjudication of that petition. But then a decision, a resolution cannot be taken unless at that stage a quorum is present. Okay, and then the joint meetings. The joint meetings are regulated by Rule 43 and provides that the committee may sit with another committee to consider a matter of mutual interest. So this is in terms of the rules. So if this committee fails at any stage that perhaps a matter that is considering, it will be best if the portfolio committee exercising oversight over that portfolio could be present, maybe just to give a better perspective of the issues. For instance, I'll give an example. The portfolio committee on health knows the budget of the department, knows their targets, knows their strategic objective, but we as the petitions committee, we do not have information regarding that. But if we consider a matter which we think may need that insight, we may invite the portfolio committee on education, so that whatever the department is saying will then be either be corroborated or rejected by the portfolio committee, because they have a more insight into the affairs of that committee. So it just only to enhance the capacity of this committee when it deals with issues that they may not be private to chairperson. But this will then be a discretion as to whether the committee will want to do that or not. And then there's a provision in the Act which deals with the delegation of powers. And it provides that the committee may delegate its powers to a member of the legislature. So a member means a single member of the legislature, or members of the legislature, provided that no fewer than 2 members may conduct each sitting, and the members must be a representative of all political parties. So this will occur, for instance, chairperson, where the legislature is in recess, for instance, and a matter arises which requires an urgent attention. The chairperson can decide to delegate 2 members so that they can attend to that particular issue in the absence of the committee as a whole. So this is just a delegation of the powers of the delegation of the powers to members or other members of the legislature. Jurisdiction of the committee. So jurisdiction means the powers of the committee to consider a particular matter, a particular petition. And then it says that the speaker or chairperson or a person authorized by the speaker or by the chairperson must receive petitions. So it is the speaker, the chairperson, or a person authorized by the speaker or by the chairperson who must then receive petitions. So this person is whom we call the petition officer, who then receives all the petitions on behalf of the committee and the speaker. And then it provides that the committee must consider every petition received in terms of this act. And there are a few exceptions there in terms of where the committee may not consider a petition, and that exceptions are that the committee must refuse to consider a petition concerning a matter pending before the court. So if there is any matter that is pending in court, we know that as the committee we cannot interfere with that process. We have to leave up until it is finalized. And then the second one is that we must refuse to consider a petition which originates from a prisoner and is concerned with his or her case, or we must refuse a petition which is before a commission of inquiry. So this is just to preclude the committee from interfering with other processes, legal processes. And then the first provision there said the committee must, and there's another provision which says the committee may refuse. This is one of the other exceptions. The committee may refuse to consider a petition that is illegible, that is not signed, or that does not reflect the name of the petitioner. So the committee here will have a discretion whether to consider it or not, depending on the circumstances. The committee may not consider a settled petition unless new facts are presented which necessitates the reconsideration of that petition. So if we have finalized a petition, we cannot go back to that petition unless there's new facts which will then prompt the committee to reconsider it. The petitioner is entitled at any stage to withdraw his or her petition, provided that if the committee considers the petition to be of public importance, the committee may continue to act on the complaint. I think that is clear, Chairperson. I may not elaborate on that. And then lastly, the committee must give reasons to the petitioner if it refuses to consider a petition. So if for any other reason we have refused as a committee to consider this petition, we must just write to the petitioner and say, we are not dealing with your petition because of 1, 2, 3. We must inform the petitioner. Powers and functions of the committee are dealt with in section 8.1. The committee must consider every petition with the view of settling the matter to the satisfaction of the petitioner. So here, to the satisfaction of the petitioner, I think it's very objective and very debatable. It will depend on the circumstances of each case, what and how and when will the petitioner be satisfied. Where applicable, advise the petitioner of available remedies. So this provision recognizes that we may not be able to deal with certain petitions, and in that case we must advise the petitioner to follow the relevant channels or remedies that may be available for him or her to settle that petition. So what is meant by considering and settling a petition? To consider is basically to hear and determine a matter and make a recommendation or a determination on that matter. However, in doing so, we must be aware that the committee is not a court of law, Chairperson, and thus may not pronounce on an issue where the guilty or not of any person is in issue. Also, there are issues that involves whether a person or a respondent is liable for damages or whatever, so we cannot deal with those because those are matters that are exclusively for the courts to determine. And I'll give you an example. There was a matter that we have considered which relates to the Department of Health, where the mother actually died during birth, and the petitioners were alleging that the department was negligent, and therefore they want compensation from the department. So this is an issue which requires one to determine whether indeed the department was negligent, and we know we don't have that competency. This is the competency of the courts. So in that case, we had to then advise the petitioner to follow the necessary legal processes so that they can sue the department in that case. But as the department, we did not have that competency. Again, they are bodies which in law have been or have the jurisdiction to deal with certain matters. These are your public protector. We know the powers of the public protector. They can deal with which issues, and then they can, at the end, they can make a determination. So if an issue is an issue perhaps that the public protector may consider or is considering, we know we cannot deal with that. And there are also issues that, for instance, deal with issues of unfair labor practice. And we know that if a petitioner brings an issue to the committee, which having considered that issue, we realize this is an unfair labor practice issue. We know that in terms of the Labor Relations Act, any issue that relates to unfair labor practice is the jurisdiction of either the Bargaining Council or the CCMA. Then as the committee, we cannot deal with those issues, Chairperson. Issues that relates to land restitution. This is a land restitution process whereby a claimant wants, a person wants to claim a piece of land in terms of this act, we know we can refer them to those. We cannot deal with those issues, Chairperson. And one last aspect is that the committee may resolve a petition by way of negotiation or mediation. So instead of us adjudicating on a petition, we can have a mediatory role or negotiate so that the parties can then agree on a certain solution instead of us determining or adjudicating on an issue. So we also have the powers to invoke the negotiation and mediation processes, Chair. The next slide. It still deals with the powers and functions of the committee. Section 8.2 provides that the committee may recommend the referral of a petition for consideration by the legislature, by the committee of the legislature, the MEC, or the municipal council. These are your local governments. And then it provides that, I'm not sure by the legislature, but it means maybe we can refer a matter to the House for a resolution. I think that is what it meant to say that we can recommend the referral of a petition for consideration by the legislature or to another committee of the legislature if we think that a particular committee can best deal with that issue. And then if the petition has been referred to the MEC or the municipal council, the committee may direct that such body must consider and make a decision or recommendation or dispose the matter in any other manner expedient and request a response within 4 weeks and request a detailed report on how the matter has been dealt with. And if the committee is of the opinion that the conduct of the person, body to whom the petition was referred is unsatisfactory, the committee may lodge a complaint with any state institution, Chapter 9 institution, or take any other appropriate action. The committee may conclude its consideration of a petition if it is of the opinion that no steps or further steps may be taken to settle the matter. The next slide deals with the evidence before the committee, which is in section 10. For the purpose of ascertaining a matter relating to a subject matter of a petition, the committee may subpoena a person. To subpoena is to summon or to compel someone to appear before the committee. To subpoena a person to attend a sitting, to give evidence or produce document or any other object. The subpoena issued must be signed and it must be issued and signed by the chairperson. We have a template of a subpoena or a summon where if the committee decides to subpoena any person, be it the MEC or any other person, then the chairperson must issue that under his signature and then that person can be subpoenaed. Before giving evidence, a witness must either take an oath or make an affirmation. So which means that if we have convened a meeting of an adjudication meeting and there's evidence that has to be adduced, that evidence must be either under oath or the person must have made an affirmation. So the purpose of this is to ensure that all evidence given before this committee is true, is correct in all respect, and it is not it's not a false representation of the facts. Because the consequences of this is that if a person makes a statement or gives evidence, false evidence, or evidence that is not true or that is not correct, and he makes that under oath or after having taken affirmation, that constitutes an offense, which is called an offense of perjury, and that person can actually be charged for that offense. Sittings of the committee may, for the purpose of receiving evidence, sit at a time and at a place in the province. So we can go out and adjudicate petitions anywhere the committee feels, but within the province. Evidence presented to the committee must be heard in public unless the chairperson determines otherwise. I think that is the issue that we have dealt with. And then also in terms of section 118, public access and public involvement in all activities of the legislature. And then lastly, the chairperson must give public notice of all sittings of the committee. So which means if we are sitting to adjudicate petitions, there must be a public notice of that particular sitting. Offences are dealt with in section 11 and 12. There's a whole lot of offences that can be committed in terms of this act. Firstly, if someone fails without sufficient cause to attend a meeting of the committee after he has been subpoenaed to attend, someone who fails to remain in attendance until the completion of the sitting or until excused by the chairperson. And then if a witness attends and refuses without sufficient cause to be sworn in or to take an affirmation, that also constitutes an offense. So if someone comes in and refuses to take an oath or to make an affirmation, that in itself it's a criminal offense. Giving false evidence, I've dealt with, that is where a person gives false evidence after he has been sworn in or after having taken an affirmation. Failure to produce books or documents. If a person uses abusive language or behaves in a contemptuous manner during the sitting, there's a whole lot of offenses. They continue to the next slide. Threatens or obstructs or unduly influences a person to refrain from giving evidence, threatens or obstructs or unduly influences a witness not to produce evidence. And then the next item deals with penalties. So if a person has committed any of these offenses and is found guilty, that person can be liable to a fine or imprisonment not exceeding 12 months. So maybe just to highlight on this issue, in 2010, we had a petition which was brought to this committee by a civic organization, Sanko in Blowback, complaining about several issues in the Blowback municipality. And in considering this petition, the committee subpoenaed or summoned the municipal manager as well as several employees in that municipality. So what happened is that the municipal manager refused to appear before the committee, and he also instructed the officials that we have subpoenaed not to attend the sittings of the committee. Then the committee decided that criminal charges should be opened against or laid against the municipal manager, which was done. The matter went to court, and the municipal manager was actually found guilty and was fined. I think it was fined about 10,000, part of which was suspended, but he was actually charged and found guilty for not having honored the subpoena, and also for obstructing or threatening or unduly influencing the employees of the municipality from not attending the sitting of the committee. Delegation and accountability. I've dealt with delegation. With regards to accountability, there is that the committee must actually table quarterly reports to the legislature in respect of all petitions that they have considered, and must also table an annual report of all its activities. And the report must provide evaluation on the responsiveness and timeliness, the efficiency within which the petitions were dealt with. Chairperson, the next slide deals with the administrative support staff. I may not deal with that, Chairperson. It deals with the processes of having received a petition, preparation, the translation. I'm not sure if this is relevant for this presentation, Chairperson, but this is the matters that the support staff of the committee are familiar with and they deal with on a daily basis. Okay, the next slide, Chairperson, and this one will be just a bit controversial, but maybe it's important to deal with so that we have an idea of what our approach should be when we deal with petitions relating to local government. And I've indicated that local government, it's a sphere of government on its own. So we are receiving a lot of petitions where respondents are municipalities. And the question is this committee, being a committee of the legislature, able to exercise oversight over municipalities? And this is the question, Chairperson. So I've prepared this slide just to share with you just my views and the approach that we have been taking as this committee. And firstly, with reference to section 40 of the Constitution, which deals with cooperative government, where we have three separate and distinct spheres of government, where we know that one sphere of government may not interfere with the other sphere of government, or may not assume the power that is reserved for another sphere of government. And we know that as the legislature, we only have oversight over the provincial executive and the provincial organs of state, not necessarily over municipalities, because it is a separate sphere of government. However, Chairperson, there are provisions in the Constitution. The first one, which is section 139, where provincial government, not legislature, provincial government, the executive, can interfere in the affairs of local government. That is where it can place the municipalities under administration in terms of section 139. And then we also have other provisions which deals in section 115, which deals with provincial monitoring of local government, which is provincial government must, through legislative, which provides that provincial government must through legislative and other measures, provide for monitoring and support and promote development of local government. And then we have another provision in terms of section 1157 of the Constitution. Provincial and national government has the legislative and executive authority to see to the effective performance by municipalities in respect of matters referred to in Schedule 4 and 5. Those are the matters relating to the legislative competency. And then lastly, in terms of section 106 of the Municipal Systems Act, the MEC for local government may intervene if a municipality cannot fulfill statutory obligation or if fraud, corruption, or maladministration is occurring in the municipality. So, Chairperson, we know that municipalities are a different sphere of government, and we may not necessarily exercise oversight over municipalities. But we know that we exercise oversight over the provincial executive. And in this particular instance, it is the portfolio of COGSTA, who in turn also have monetary powers over the municipality. So I can liken the relationship, Chairperson, between the legislature, the executive, and the municipalities as that one of the grandparent, the father and the son. We know that the father does not have direct parental rights and powers over the grandson, but he has those powers over the father, and then the father has over the child. So which means the grandfather, the grandparent, being the legislature ourselves, can have indirect oversight over the son, which is local government, but through the executive, over whom we have the oversight powers and accountability. Not sure if that makes sense, Chairperson, but let me leave it there. This is the end of the presentation, Chairperson. I'm all yours in terms of the questions that may arise. Thank you.
Well, thank you very much, Mr. Kaza, and for the presentation. And let me take this opportunity to welcome Advocate Andantswana, Senior Legal Officer from South African Human Rights Commission. We have actually invited them to come and make presentation to this committee because, as you understand, we'll be working very closely with them. They will be actually one of our important stakeholders as and when we go out to the public, so that we from time to time can educate the public about their women's rights and so on. So you are most welcome, and I will then have to get guidance from the committee whether we should then ask for questions or questions or clarity-seeking questions, or we allow them to present first, and or maybe we deal with these clarity-seeking questions from the presentation that we have just received. Okay, no, let me just correct it. They are not here for presentation. I'm told they are just here for meet and greet, just to introduce themselves, since we are going to work together, because you will remember that we have invited them in our second induction. So then I could then allow them to quickly introduce themselves, and from there we could then engage in the clarity-seeking questions from the presentation that we have just received.
Thank you, Chair, Speaker, and honorable members. Just a quick introduction, also an indication from me. I would have done the
leave me alone.
Let me see if we have other hands before you bring them. Honorable Knox and Honorable you follow in that sequence.
Chair, thank you for the opportunity. There are two issues that were raised by Russell. One is the question that he posed as to whether a member of parliament can submit a petition. And I thought Chair will be relying on him for guidance, because we are members of parliament, and he left it hanging. I don't know whether he would want us to resolve, or is there no answer for it in any of the regulations or laws, so that if he wants it to be discussed and we have a resolution here, we must be able to do that. Unless if it was just deliberate to provoke discussion among us, then he will give us the response later. Then we can do that. That's the first one. Meaning I will have to come back after responding to this. But the second issue is on the composition of the committee. Because it says 5 to 10. Now, there are two issues that arise there. If indeed it's limited to that, then we are 12, then we will be operating outside of the boundaries of the legal frameworks of the committee. But my understanding of the 5 to 10 is in terms of the old rules when members of the legislature were still 49. Now that members have agreed to 64, it would mean that the legislature therefore has got an obligation to go and amend the rules to accommodate the 15 other extra members, because in terms of generally accepted democratic principles, if this rule remains, it would mean that we will never have the majority party or the majority in this committee. It will mean that you will have 6 committees plus 4 members from the ruling party or the majority party, which then denies the majority party an opportunity to exercise its governance role. That's the first issue. I think that we need to agree that we are condoning the 12 with the anticipation that the rules should then be amended by the legislature. Because if we do not do that, any resolutions or decisions that we take here will be null and void, will be outside of the that's my submission on the composition of the committee. Of course, I've got a response to the first question, to the first one, but I don't know whether is there no legal response to that, so that I do not find myself discussing something that is being legalized. It will no longer allow. I'm very skeptical. But I can engage on that if there is no specific rule that talks about honorable or members of the provincial legislature giving evidence. I don't know whether they are saying in their personal, remember, we at some point cease to be members of the provincial legislature. Whether it's in their personal capacity or exercising or submitting that petition as members of the provincial legislature, I do not know. Thank you very much.
Thank you, Chair. Chair, if you do is it the research, so I'm still not knowing everyone by name. If I understand you correctly, we will only have indirect oversight over municipalities. Now, as an example, let's say we all have water issues all over the province. Let's say a water issue petition is submitted, let's say for one municipality, for example. What will practically take effect? Will the MEC because remember that's a national competence and not a provincial competence. So who will then actually appear before this committee? Are we now interfering with national, or will the mayor come and present his report, his or her report? Maybe just a practical example as to how such an issue will be dealt with. Thank you.
No, thank you very much. No, I said only two questions, but one, Honorable Colonist. So the second one, I just wanted to check from the previous financial year, how many petitions were they dealt with, and the outstanding. Do they have an outstanding that needs to continue, just to check it? I think previously, Honorable Mkwanyani, yes, there was this committee, but there was no vavavoom that we didn't hear people saying this and that, because what we heard is people complaining that there were issues that were sent, but I think were not resolved. They didn't hear anything. There were no, they were not even going back to the people to report back how they did with their cases. So what just wanted to check, because taking over, I think most of us here, we are new in this committee. So wanted to know, going forward, with the outstanding issues, if maybe they could just try to empower us with that information so that we know, okay, this is what they've dealt with, and this is how they've dealt with those issues, and then for us going forward, this is what
I think you were able also to capture the questions from honorable members. Maybe as and when we also try to respond to the issues raised here, maybe just going back to what honorable Mkwanyana said, and I hope that even the rules committee has actually looked into the composition of this committee. But I guess that as and when these rules were adopted, that was by then, members of the legislature were 54, as vis-a-vis what the 64 that we have currently as members of the provincial legislature. And if that what we are saying supposed to be like that, what needed to be done, we then have to make sure that the rules are needed. So that whatever that we do, we try to do it within the framework of the law. But we also rely also on your guidance on that one. And I think maybe I should just give you.
Okay. Because I sit in the rules committee. The rules have been amended, Chair. They were now between 8 and 13, if I'm not wrong. That we are at 18, the maximum number of, in all committees. This rule does not only apply to this committee, it applies to all committees. It's now between 8 and 13. I'm not so sure about the 8, but I know that the maximum number is now 13. So we are within the rules now. I was saying, I wanted to specify whether is as per this rule book, or is it the legal somewhere that I do not know. But if it is as per this framework, this committee is in order.
Yeah. And that's why I was also bringing the issue of the rules committee.
Yes.
But the Tekoza will then have to come in on that
Yes.
one. And also respond to what Honorable Mugawa has raised. But just maybe as and when we'll be responding, I mean, out of, then I'm speaking under correction, out of 89, 89 that was received. Penny. No.
That was
that were actually referred to organs of state.
Chair,
That was,
as a matter of procedure, I think that we've got 5.2 and 5.3 that we can do petitions that are outstanding or what. So I was just skeptical that we jump into items before we get into them.
no.
That is
The
fine.
question was based on the presentation, but it's fine, let's leave
Yeah.
it in terms of
Yeah.
procedure, yeah. Okay. But maybe you could then respond to issues that was raised.
Thank you very much, Honorable Chair. The first question from Honorable Mokonyana, there was with regard to the issue of a petition emanating from a member of the legislature. Indeed, this issue arose in the previous term, Chairperson, and we had to be called in to advise on the matter. And it is not something that is provided in the Act, but then our advice, which the committee at that stage felt comfortable with, was that the legislature is composed of members of the legislature who comes from different political parties. And the committees also are constituted by those members. So, a situation that arises where a member of the legislature, in his capacity as a member of the legislature, submit a committee to the legislature. Basically, submit a committee to himself, a petition to himself, because he is a member of the legislature and he's supposed to deal with that petition. Not him personally, but another member of his party will have to deal with that petition. Is that not a conflict of interest? And we advised the committee on that basis that even though it is not provided in the Act, it will not be appropriate for a member of the legislature to submit a petition to the legislature. And for the fact that that petition was submitted on behalf of someone else, the advice was that we rather have a situation where that person submit a petition to him or herself, rather than that member submitting it to the legislature. And the committee felt comfortable with that advice, Chairperson, and going forward, the issue of a member of the legislature submitting a petition was not allowed in the committee. That is how we dealt with the issue, Chairperson. So the second issue is with regard to the composition of the committee, with regard to the number of members, Chairperson. I've heard Honorable Mokonyana say that the members actually been changed. I'm not sure if it is in terms of, because I'm not even aware if the new rules have been adopted, but I'll work on the basis of these rules, Chairperson. These rules provide that the members may not be fewer than 5 and not more than 10. So this is the maximum and the minimum and the maximum. And this issue has arose, we were engaged as legal services by the Speaker, I'm sure maybe it was also from the Rules Committee, to say that what do we do in this instance, because the increase in the number of members will necessitate the increase in the composition of committees, which we all agreed. But then we then referred them to the specifics, framing of this rule, 36, Chairperson, which deals with the composition of the committee, which provides that a committee consists of a number of members that the Rules Committee in each case determines, but which must not be fewer than 5 and not more than 10. Unless, and this is a proviso, very important, unless this rules provides otherwise, and we know there's nothing in the rule that provides otherwise, or the House directs otherwise. So, which means, because according to the Speaker and the approach of the Rules Committee, they wanted these rules to be amended so that we can cover that eventuality of the increase of members. But then our advice was that there is no need at this stage to amend the rules, because this proviso actually covers that increase. What we only need to do is to have a resolution adopted by the House to say that the number of members can be increased. So that is the basis upon which this issue was approached. So as to whether that resolution has been made in the House, I may not be privy to this because I'm not sitting in the programming. Also, I'm not sitting in the. It was.
No, it was.
All right.
If you have confirmation, it was.
Okay.
Through you, Chair.
Thank you very much. And then the
Because
issue by.
that was actually very confusing because I thought you were actually reading the different standing rules that because you were just confirming something from the rules of but nevertheless
No, Chair, just for ease of reference to members, these rules are old rules. What we did in this legislature, we adopted these rules twice, actually, since the 7th administration. We adopted these rules as they were because we wanted to operate as a legislature. We couldn't start a new book like this because we did not have the legislature. We have to have the legislature. Hence, we adopted this rule. After we had adopted these rules, we picked one or two issues. I can't remember which one was the second one, which we said we cannot operate also if we do not amend these ones because we have adopted the rules. Now we can amend them. Hence, we then came with what Semi said. It is correct that we said what we only do is to increase the composition. I think it's from the minimum is now 8, if I'm not wrong, and then the maximum is 30. Yeah. So we are in order here. You can continue covered.
And I've skipped one issue, Chairperson, which I think is also very important. The issue of the majority risk. So, Chairperson, the rules also recognizes that there may be what in terms of the rules we say it's an equality of votes, where let's say in the previous constitution of the rules, where members are 8 and there's 4 for the yes and 4 for the no. So it means the committee cannot take a decision if there's an equality of votes. But there's a rule, I'll just check which rule specifically, which gives the chairperson a casting vote in addition to his or her vote. So which means there should never be an equality of votes, because the chairperson always have a casting vote in addition to his or her vote as a member of the committee. So if there's an equality of vote, the chairperson will have a casting vote. Thank you.
there's an issue that we have not responded to, the issue of honorable
Max, yes, I'm coming to that one.
I thought you were handing over to me.
No, yeah, Chairperson, I've tried to illustrate what and I know it's a very controversial issue, Honorable Mark, but unfortunately this is what the situation is. And what we have been operating, how we have been operating with municipalities, we are operating on the basis and on the understanding that we do not possess oversight powers over them, and that is constitutionally pure fact. We do not have oversight over municipalities. But the structure that I've outlined to say that we may have indirect by virtue of us having direct oversight over local government, over the MEC of Coxstar, who has direct oversight over municipalities. So through the MEC, we can have oversight of, though it will not be as direct as if it was over a provincial department, but through the MEC for instance. So where there are issues, like you have mentioned the issue of the water authority, we know that there are municipalities who are themselves water authorities. We can engage with them directly. But where in that municipalities, the water authority is still national department, that's where I've said that we can still engage, but we cannot have direct or intervention with national. So we need to have a mechanism in terms of how we can then deal with that issue. But we cannot directly over that municipality engage on that issue. So ordinarily what will happen is that the community will not know who is the water authority in the most of them do not know. And once we engage with the municipality, we'll find that this municipality is not a water authority. It also depends on national, and then we just find ways of having to facilitate the matter, but not directly. I'm not sure if that answers the question.
No, but it's confusing still, because you say what Honorable Max was saying was that we receive petitions. Remember, these petitions, they are not necessarily from the municipalities. They are from individuals or from the public. Now, when they send these petitions to us, then we refer these petitions back to a particular municipality. And when that municipality is not actually addressing or responding to what we are actually being referred to them, now we still have the authority also to summon them to come and explain here, not necessarily playing an oversight role. Yes. But we have that responsibility because part of our responsibility is to make sure that that petition is actually addressed. So we can't say, no, we doesn't actually have a role to play in that instances. And I think that's the area that we also have to attend to. Yeah. So, Honorable Cooper, Honorable Machete, Honorable Max, and Honorable Konya.
Thanks, Chairperson. With regard to this issue of water, we can't just say we don't have an authority to summon. We do have an authority to summon the municipality because the same municipality it has a water authority. If the local municipality doesn't have water authority, the district might have. We can summon the district, or we can refer the petition to the district. As a problem, it's not a problem. We can solve it. Thanks.
No, thanks very much. It's just on the generic approach in relation to the interpretation. On the issue of the standing rules and petition acts, there's a reference, and I think it must be clear as to which one gives effect to the other. But we also link that to the petition committee with the Constitution, so that in the execution of the task, we are clear in terms of the demarcation and what is it that needs to be done, so that we are not seen to be overreaching. We are able to take that element of property. So I thought that interpretation will help just to say which one gives effect to that.
Honorable, I'm not sure if you are correct, Honorable Konya, then you did the last Honorable Max.
No, Chair. Before we adjudicate any petition that comes to this committee, the first thing that we must establish is jurisdiction. Once we have determined jurisdiction, you will not have problems that we are talking about. Because jurisdiction would say, Mohalap and a local municipality, Comrade Cook. You are not going to summon the district municipality because the district municipality is not being petitioned by anybody. It is upon the response of the Mohalabena municipality that has the committee. You can therefore then decide to assist Mohalabena municipality in responding to the petition by then calling for the district municipality to come and respond. But the primary responder or to the petition would be the petition person who will be the Mohalabena local municipality. That's the jurisdiction institution in this instance. Thank you.
Thank you, Chair. Chair, practically what I think, let's say a citizen resident, let's use column 1 because we are sitting here, submit a petition to this portfolio, to this committee, then on water specifically. That would imply that we don't have direct oversight of the municipality. But then at least when we receive the report, there must be a heading or a category to say petitions refer to the municipality. And I think then the 4 weeks timeline can still be utilized to say, this is a petition, use it in terms of your rules. Then if they do not respond, then it should be able to come back to this committee that they did not deal with it in a 4 weeks time, or in terms of the rules as the case may be. Because in terms of the Constitution, we can also take over their responsibilities by way of administration. And if we don't do that, we will never know that they did not comply with certain petitions. So there must be a way for it to come back to us, not to deal with the petition, but to see whether or not they dealt with petitions at all. I hope that makes sense. I don't think the Act needs to be amended to that sense, but I think it will more be a procedural function of this committee. I hope it makes sense, Chair.
No, it makes sense. In fact, that is how it works.
My apologies, Chair. I'm quite new.
No, you are correct, you are right. In fact, it's important also for you to raise whatever that you raise. What will then happen after it has been referred back? If there is no response, we also have an obligation, either to someone or someone that a particular organ of state or that municipality, to come and explain why, because it will also give them timeline. Ultimately, all what we need to do, either in a process of mediatory role or whatever, but ultimately that the issue raised by the petitioner has been attended to. So we must also have a way that the matter gets to a total finality, or how the matter has been closed.
Want to say it's a habit.
So, yeah. But, you know, it also goes back, even if Honorable Mukonyan was saying the issue, and I think what you have asked, because, you know, this was just a way of, because we then have, it goes back to how many, and majority of the petitions that have been referred back, or many of the backlogs that we have, is because of, we still have these backlogs because there is no response either to a particular organ of state or that institution. And we should also have a way of actually dealing with that, in making sure that we have either a program or a manner in which we have to close all these backlogs that we are having. I thought it makes sense to another comments. Or you still want to come back?
No, I don't. I just want to find out if perhaps the sentiments by Honorable Macheto will want a response from me, or is he fine?
Just assist to respond.
Oh, yeah, this is a general one, Honorable, to say that we know that firstly the Constitution will take precedence, it's the supreme law, and then we then have the rules, or let me rather say the Act, because this Act has been passed as law in the legislature. So that will also take precedence, and then obviously then comes the rules, because the rules have not been enacted as law in the sense, in the strict word, in the strict sense of the word. So my view will be that as and when we deal with issues, and maybe there's a conflict of interpretation and otherwise, we should first take precedence on the Constitution, and then the Act, and then the rules. So which means that if the rules are in conflict with the Act will then supersede. And if the Act is in conflict with the Constitution will supersede the Act. So I think that is the basic hierarchy of how we should then be interpreting the issues as we deal with them when we deal with petitions.
I think it's clear. Thank you very much.
Thank you.
For that clarity. Honorable members, I think we can then proceed to 5.2, which is the briefing on the reports regarding referrals, August 2023, December 2023. Or maybe deal with, I've seen there are also addendums as a way you do these referrals. I'm not sure who start.
Those are the ones who didn't respect the research.
This person, for the research. Okay. No. Who should start then?
No, it's me.
Okay.
Yeah. Okay, Chairperson, as per the request by honorable members, that we should circulate this report. The report was circulated to members, and definitely members have conceived. Yes, and but by and large, Chairperson, this report contains, let's say, the representations and complaints from various petitioners, and generally, these complaints, they complain about the fact that there are no services provided to them, or there's no service delivery, or there's a lack thereof of service delivery. And there is this challenge of lack of responsiveness from various organs of the state. And this report, in general terms, most of the representations and complaints that are in this report include, but not limited to the ones that I will be indicating. There are those who are in need of RDP houses. There are those who complain about the installation of electricity in their communities and some in their houses. And then there are complaints around the roads and generally upgrading of roads from gravel to tar. And also others are just requesting that in the event that tar is not yet done, then there should be re-graveling and also continuation in terms of maintenance. And other petitioners complain about clinics that, as I've indicated, that somewhere they do complain that we don't have clinics, and then somewhere petitioners will complain about the effectiveness and efficiency or functionality of those clinics. Others are requesting that they should be 24-hour operational, and then those are some of the complaints and or representations that were made before the committee. And also others are, in this report is about destitute families, yes, those who are requesting that they be given RDPs, and others complain about speed humps, others complain about bridges, and then claims for, and others are about claims for chieftaincy. And then also, this report, in general terms, the report outlines the extent and the degree to which petitions are affected, to which communities and petitioners are affected by service delivery, depending on the context of each petitioner and also of each community. Then, generally one can say there is lack of responsiveness of organs of the state. As we have indicated in the previous meeting, that we have what we call pending petitions, meaning those that have been adjudicated by the previous in the previous term, and then they were not responded to accordingly. And there are those that have been adjudicated in the previous year, those that have been adjudicated last year, from August until December, in the previous year, those that we have been adjudicated by the committee are those that are included in this report from August until December. And it's like there are 36, if I'm not mistaken, but they were dealt with in various forms. And then, but the point of emphasis is that, honorable members, there is a serious lack of response from organs of the state. We refer them these letters, but they don't respond. And then, even when some try to respond, but we find that the responses are not that satisfactory. And I think that is the major issue that as the committee we are going to deal with. And the other issue that I want to raise in respect of this report is that it shows that there is no communication between the organs of the state and communities in the event that such services are not delivered. That's what has been found to say, even when there were promises of particular services to be delivered, but when in the event that such services are not being delivered, you find that there is no communication between the responsible functionary to the communities concerned. But then we can say in terms of this report, we had petitions, about 18 from Capricorn, Stukune 8, Wembe 6, and then we have Mopani 4. And then they were dealt with in various ways and forms. And then, as I was saying to the chairperson, that if I can try to go with them in detail, this is a very big report. And then, but anyway, besides what I've just indicated, if you go through the report, it shows those from Capricorn, those from Mopani, those from Waterberg, and also Skuku. Yes, in brief, I can say I can keep it like that.
Thank you very much, Dr. Rajuma. I think that is the report that we have actually requested. Just maybe they must present the observations and the recommendations, and the report itself has recommendations on page 51, which I think the honorable members will also go through them. So maybe I should then allow honorable members to engage on the honorable member.
Which I thought the report was just for noting, and that was the reason I had to note it.
Any second
Yeah, no, thanks. Yes, I second the report. Of course, I also would want to just have a bite to say, of course, the question that we need to answer is, what is it that we should need to do? What are we empowered to do as a committee? Because what the presenter was indicating is that there is a serious non-responsiveness from the organs of state. What it means is that at the end, as these petitions get referred and they are not attended to, the committee then becomes just a toothless organ because it doesn't try. And obviously, the more the petitions are forwarded to the committee, and they do not get addressed, the issue of trust from the communities will then get exacerbated because they will therefore not have any trust in us. That's why I'm saying that we need to answer the question, what then needs to be done? What is it that what powers do we have of enforcing whatever that these referrals that might have been sent to whoever and the departments. Because if we just refer, they don't respond, follow-ups are made, they still don't respond until the term ends. The issues that the people have raised do not get addressed. So that's what I just wanted to highlight, Chair, to say that we need to be thinking to say, what else we do? What is it that we can do? Because it can't just be, no, we have done our work, as long as we've made those referrals, then we have done something.
No, thank you very much. I think what we need to emphasize is that it's not going to be business as usual. This committee is going to be functional, and we'll make sure, because even the report itself, findings and the recommendations are very clear, and we then have to move swiftly in terms of Section 11 and 12 of Petitions Act. It also empowers empowers us to either subpoena or call or summon any board. If we have actually referred these matters to a particular organ of state, and they are not responding, or one in control, we then have to invoke the relevant section 11 and 12 of Petition Act, so that it's in the committee it's not going to be business as usual, so that we start to make sure that the issues raised by our communities are taken very seriously. So, but I think that was also addressing the area of your concerns, Honorable Pokan, to say we can't, and that's what the example was saying, we can't behave as if we are powerless. And while the Act empowers us to do certain things to perform our responsibility, and we have to do exactly that. And I think I was actually responding to what you were asking, but I think the report has been limited, because we then also, at a particular time, we then have to go and debate and deliberate on the report at the level of the legislature.
Just imagine this issue of application that were requested house for 20 years. And there's no feedback from the department.
What? I agree with you. When you look into all the petitions, some of them dated back 2022. But when you also look that we are awaiting the response from a particular organ of state or a municipality. So we then have to make sure that all these issues are actually attended to. Like the issue of blowback, on how it has been handled, as and when the presenter was presenting. Those are the route that we should take, so that the standing committees actually take it very seriously. Honorable Pokan.
Yeah, Chair. I would suggest that we need to then say, because most of what is captured in the report is on issues that dates from far back. What then needs to happen now? How then we say, do we still keep on waiting for responses? Until when?
No, what we should then do is now for us to know the report like we did, and the administration side, they will then have to go and categorize all these issues. Because I think where we are sitting, most of the work that we need to do, if we are going to a particular district, we then have to make sure that if we have to subpoena particular people or certain department or certain municipalities, we deal with these issues that have been outstanding. Look at the backlogs. The backlogs is because of the lack of willingness either from these organs of state to respond to some of these issues. So, and it's for us to make sure that as and when we have categorized them, as soon as we start now summoning these particular municipalities and these organs of state, then you will see they will start to respond positive. And all these issues that have been raised here, I was just looking into 7.5 of the recommendations. It says the MECs and mayors should develop a sound plans to ensure that stakeholders management are in endeavor to avoid the risk of community protest. But when you also go back to the findings, it says the attendance, 6.7, the attendance by MECs when requested by the committee was worrisome. So that we can't be a committee without TV. We need to make sure, like the example of blowback, so that this committee should be taken seriously. There is no way in which we would allow certain things or this committee to be taken very lightly. Let's exercise, let's make sure that we invoke section 11 and 12 of the Petitions Act, so that people started to be accountable. I think that suffices in response to the question that has been asked by Honorable Poka. Yeah, I understand. I've gone through the report. I've seen. I've looked into. It's worrisome, but as the committee, we must make sure that we attend to all these issues. Honorable Mukanya.
Chair, I thought the report was requested so that the committee will have a working document starting from now going forward. I was not aware that you would have wanted to discuss the committee. There are a lot of issues if we were to discuss that report. One of the issues would be talk to follow-ups that we do. When last did we follow up with those departments? So before we throw accusations, and then let us just be careful so that when we get to the gist of the report, then we are able to understand what is going on. I was just cautious that if we load the report for today, let's load it. But if you want to get into discussing it, let us have more time to discuss it. Go resolution, petition by petition, resolution by resolution, and how practicable some of our resolutions are. Some of the resolutions that we take are not even assisting, they are not even practicable. We can't even follow them up because they are so open that it becomes difficult for the people. So hence I'm saying, when I said we know the report, I was avoiding that we just jump into it because there are a plethora of reasons why certain things did not happen. And I do not want us to go back there. I said, we have got a working framework as a new committee. We have got a new chairperson. We know that the chairperson teeth is going to bite. We will support it. Let's do the report and start working on it. Yeah. When there are follow-ups, then let's follow up. One other issue, Chair, is that I would prefer when we submit a report, we also submit as to what did we do as a committee. We went to this petition came here, we discussed it, we resolved. To resolve a petition is not to close it. You resolve a petition by saying the department must do 1, 2, 3. Now, what happens after that? What do we do then after that? Who must do what? So, those are some of the issues that I said when we get into this, we must grapple with and make sure that we make very, very tight resolutions that are compelling for people that those resolutions are taken up on to get it. So as I said, when they said, let's know that, but we'll discuss it. We can spend 2 days talking about those resolutions and all those. But that will be time that we must allocate to that. Yeah.
Let's just agree with the principle that's established. One that we will have to have a full day or 2 to deal with the report. And from that, then we'll then have an action plan in terms of moving forward. But as we speak, we are agreeing that
challenge is the issue that Honorable Mokoen raised to say, when could we have done the follow-ups from our side? So maybe moving forward, we need to say, even before we can come and have a meeting, they should do the follow-ups. They should do the follow-ups so that when they come and make a presentation, we are aware that, yeah, these people indeed are really reluctant to address the issues, so that we could be able to then come up with ways of addressing those issues.
Maybe we might not be on the same page, but this is the report that was actually also adopted by the 6th administration. What happened, there were processes that were followed. And I think the last time when we met here in our last meeting, we then agreed to say, at least we must actually have the gist of what happened and what are the issues, what are the findings and the recommendations in the previous report. Now, all what is needed, when the process, when the adjudication, there are certain processes that have been done, and if we need evidence of that, they could be provided to us. But I just wanted to clarify that so that even when we are going to deal with the new petitions and others, we must know what processes and so on. But the worrisome and the findings and that, what are the recommendations, they are also one of the challenges that have been raised by in the last administration to say, even if we are not in the report, because at a particular time we also have to go and debate on these issues at the register, on this report with the legislature. But after we have noted it, at least we have an understanding of what are the issues that were raised and what are the findings and the recommendations from the 6th administration. So I thought all what, and I agree with what we have been, on how we are going to deal with the new petitions, but at the same time, we can't leave these ones unattended. We must also have a way. That's why we're saying we must actually have a way of categorizing it. And you will see as and when the processes unfold on how we are going to attend to those. I think that clarifies, or unless you also want to help me support. It's covered. Okay. No, they are saying no, it's covered sufficiently. Then we could then proceed to the next presentation. Consideration of the new petitions, and you can flag it. Oh, okay. So it's just we can start.
Morning, honorable members and colleagues. My name is Joyce Malaji. I'm going to table the new petitions starting from last year, October, until September. I've categorized them by districts. The first petition that we've received from Capricorn is from Hoba community, Lepello municipality. Request intervention for installation of electricity for Makuba community 127 at Rama Tabata. We have referred that petition to Lepello Kumbi. Several follow-ups have been made, but no report until today, since last year. The second one is from Shenima Kosa. Request assistance on the inquiry of an applied birth death certificate. This one, the committee does not have any jurisdiction over this matter. We have advised the petitioner to take the matter to public protector, and also when we were trying to assist him We also checked with the Home Affairs. They told us already the public protector has this matter and they're writing the report to the public protector. The third one from Capricorn is Tivani Taxi Branch. The allegation of non-assistance regarding registration of Tivani Taxi Association by Department of Transport. In their petition, they alleges that they have requested the department to assist them in registering the association. In fact, they were under Bakoni Taxi Association, which is a joint one in that side of Tigran. So they want to disband from them. In fact, they were married together, so yeah, they want to divorce. And then we referred the petition to Department of Transport. And the report from the Department of Transport, the law does not allow registration of new, they said in their response, they said they don't allow new registration for now. So we forwarded that response to the petitioners, but seemingly they are not happy. We don't know, and also the report we forwarded it to research section for them maybe to analyze it better, to report to the committee. The fourth one is the Shehu Zone 5 and Zone 8 community. Request intervention for consolidation of houses in Zone 5 and Zone 8. They allege that for the past 20 years, they have applied for RDP houses from Polokwane municipality, but nothing. They haven't received their houses. And we have referred the petition to Coxstar and Polokwane municipality. Polokwane municipality responded that the matter is within the Coxstar, so Coxstar has not responded to us. The fifth one, Mahatura Isibe Catherine, request for RDP house. She's from Hajali village in Teflo. She has applied for RDP since 2011. Until today, we have not received the house and we have referred that petition to Coxstar. No response received. The other one is Muyeti Mahaile Morris. Request for intervention for long pending amendment application of application SNA from Muyetis. From the surname Yamuyeti to the biological surname Yagare Hasabo. We have referred it to Home Affairs. They have changed the surname. In fact, they have corrected it, whatever he was applied for. And then the petition is resolved and closed. Maruma Mashiani. Request for service delivery, water supply crisis in Seshego Zone 6. No report from Polokwane municipality. Mahlangu SJ, allegation of non-payment of accommodation while acting as district director at Department of Education at River Cross. She alleges that she was appointed as acting director under Sekukune River Cross, and then they said they will pay her accommodation and transport because she's from Polokwane, but they didn't. So she requested requested the committee to assist her in getting her the payments. We have referred it to a Department of Education, no response. Kasabo Cecil, request for installation of Kasabo Cecil and Makoba community. Request for installation of Vodacom tower and intervention in allegation of asbestos challenges in Bewas Kloof area. these are people from Hamakuba community, Hamatabata, but request installation of tower or Vodacom. They have a problem of network. We prefer the petition to Vodacom to get a report. We don't have a report. And the 1 year asbestos, we dealt with this issue in the previous term. So it was coming for the second time, but we have responded to them or we have dealt with it. Mutimele, T and others from Program Municipality request intervention for employment with regard to qualification obtained under social development. This is a group of students who are saying in their petition to say they were recruited by social development and signed contracts with the social development that they will give them bursaries and take them to Stellenbosch University in Cape Town to go and study. So they've studied for 3 years. They came back with their diplomas and they promised them that after they've finished the studying, they will employ them, but they are not employed. In total, there were 17, it's only 3 that is employed, 14 is unemployed. Mr. Maifo Simon Lepelle Nkumbi request assistance to get approval letter from Lepelle Nkumbi to develop shopping mall at Mahantla. Mr. Maifo alleges that SSMD developments, they want to develop shopping mall at Mahantla. But unfortunately, the Lepelle municipality is unable to provide them with an approval letter that is requested by rural development to say they can build there. So since 2022, they requested us to assist. We just referred the letter to municipality to check what's the problem, why, so that they can give us the report about what is hindering them. Mr. Setovia, alias Lepelle Nkumbi, request intervention to get assistance on legal assistance to legally marry a foreign national, a woman from Lesotho. In fact, this Mr. Elias was requesting information from Home Affairs. He went to Home Affairs to request for information. So they said he must bring his wife so that they can assist. But Yena and this other guy decided to write to legislature to say Home Affairs is refusing to give them information. But when we checked with Home Affairs, they said we must bring them so that they can assist them. We took them there to Home Affairs. And then the matter was resolved. They gave them the information and the matter was resolved. The chain is closed. Dr. Tousi Tumu request assistance to clean the polluted environment area, filthy garage, that threatens the life of the community in Mohodu community. This is the new petition that we've just received on the 30th of September 2024. We're still going to refer it to municipality. Sekukune district, we have 17 petitions. The first one is Matala Camela France from Mapuritama. Allegations of unfair labor practice, unfair labor practice against Mr. Matala. He alleges that he was appointed as a driver license examiner at Mapudu Tamara municipality license sections. So, but to his surprise, since the past 10 years, he was working at help desk. So he wanted the committee to assist. We've referred it to Mapudu Tamara, and then we don't have a report. Report received from Mapudu Tamara. We have a report from Mapudu Tamara. We have a report from Maputo.
Yeah, no, we did, and we did scrutinize that report, and all the issues there are relating to the issue of unfair labor practice, and we have advised the petitioner to then follow the necessary processes of approaching either the bargaining council, is it the municipal bargaining council that will be relevant, or the CCMA, whichever will help, and we have advised them accordingly.
Thank you. Down Chabeleng Traditional Council, Fetahomutubat Municipality, request for the building of traditional hall at Down Chabeleng Traditional Council. They allege that they have made application for the building of the community hall since 1996 till today. They didn't have that hall, and then we have prepared that petition to Fetahomu towards municipality. No report received. Matunyani Mamiki, Sekukune district, allegation of ignoring departmental policy in appointment processes for deputy principal at Rite Primary School. We have referred the petition to education. No report received. Bakoni Puti Traditional Council, Fetahomutubat, request intervention for appointment of headmen and headwomen within Bakoni Puti Tribal Council. We have referred the petition to Department of Coxstar. They have responded by saying the report received from Coxstar stating that Bakoni Puti Traditional Council headmen and women, unfortunately from the part of those not in the status quo, the Bakoni Puti Traditional, they are not in the status quo reports and can therefore not be recognized until such time the policy has been concluded. So we have another 1 year so Leona is the same thing, they've responded the same answer until the policy is being concluded. They are not in the status quo, meaning they will have to review the status quo. I'm not sure. Lihumo now Trachimo from Fetahomu towards local municipality. Request intervention regarding land disposition, Lewoeng Ward 26 between Orastad and Nuspruit. This one was referred to Coxstar and Fetahomu towards municipality. Coxstar has met with the petitioners and they have agreed that in future they should engage local traditional office. Marudamadibung Traditional Council, allegation of failure by the office of mayor from Marudamadibung Traditional Council, Makudutamaha Municipality. Allegation of failure of the office of the mayor and speaker from Makudutamaha to meet with the council of Marudamadibung Traditional Council to address water crisis in the community. We have referred it to Sikukuni and Makudutamaha, no report received. What 31 what 30 and 31 demarcation board from Greater Sikukuni district request intervention on municipal boundary determination on the issue of demarcation of wards. This is beyond the committee's jurisdiction. We have advised the petitioner to take the petition to the independent demarcation board. Matenchi Lucas from Greater Supuku request intervention on allegation of non-recognition of headman Lucas Ndebele Traditional Council. A report was received from Coxstar. Leona Iblelaka, they are not part of those that are on the status quo report, so they will have to wait until the policy has been concluded. Mabota Development Community, request for intervention regarding poor community service delivery. They have a problem of storage in the Mabota East Village. So also this one we have referred it to Lepelle Nkumbi. We have not yet received the report since April. Banabatari Entertainment Group, Greater Sikukuni, request for intervention on allegation of non-payment of services rendered by Banabatari Entertainment Group. This one we're complaining that they've rendered the service during Heritage Day at Rasukukune during September 2019, and then they were promised to be paid, but they were not paid. But we got a report from Sikukune that said they were paid. So the petition was resolved. Tabang, Makofan, and others requested for service delivery in Fitahomu towards municipality, roads and water. It was referred to towards municipality, no report received. Tabiso Maholeo from Fitahomu towards request for service delivery in Fitahomu. Roads, water, school, hospitals, it was referred to Sikukune and Health and Fitahomu Municipality. No report received. Ngwinikas Tembiso. Request for extension of a new section rehabilitation park in the Fitahomu Municipality. A village called Mabodile. We have referred the petition to Fitahomu towards. No report. Master Laws Electricity Crisis Committee request intervention on the agent appeal to address daily electric load reduction and implement audit in illegal connection. We have referred it to ESCOM. We have received a report, I think it's this week. We have referred it to research for the research to analyze the report. Monoiti Secondary School from Elias Mutwaledi. Request for building of community school. They allege that the school infrastructure is dilapidated and everything is falling apart. Several letters were written to Department of Education, but nothing has been done. We have also referred it to Department of Education, no report received. Mpao Patrick from Makubitamaha request assistance to claim compensation fund through Sikukune district due to ill health. Mpao was working for Sikukune district, municipality, and firefighters. Then he was he went on pension due to ill health. So he wanted the municipality to compensate him through doctor's letters. Capricorn, what's on it? We've sent it. We have sent them maybe because we didn't categorize them by district. We categorized that is the same thing.
think they will quickly.
Okay, cool.
To dispatch, yeah.
Okay. Waterberg. The passengers from Mokopani, from Waterberg. Request for reinstatement of GNT bus services in Mokopani. They allege that they have serious concern regarding shortage of GNT buses in Mokopani area. They were allocated 23 buses, GNT buses, but since 2015 to date, only 5 buses are allocated to Mokopani. So we have referred it to Lidet, no response received. Genie ASA, request for the scrap of gravel road from the entrance of Alma to Luipoort, Lupat Road. The petitioner alleges that the Alma Road to Lupat is in very poor condition. So we have referred the petition to Dimulamo Kopo. No report received. Vembe District Mashaba from Collins Chavan request intervention for poor road condition at Malamonele Shiptakis main route to tribal office. Public Works reported that they visited the road and communicated with Collins Chavan to attend to the matter. It is still pending. Matozi Samuel from Vembe. Allegations of grievance regarding outstanding overtime and claims submitted as chauffeur during 2024 to 2028. We have referred the matter to Vembe District. No report was received.
Thank you very much, Andreas, for the presentation. You show that it was a good, or she has covered you as they say in her presentation. Let's then take comments and input from honorable members.
No, thank you. Let me acknowledge receipt of the report. Of course, it assists in terms of determining where we are. But I've got 2 concerns. One, I would have thought that the report would have a separate report which would show those that are outstanding and those that have been closed, so that they're not though they might have been in one report, in the other report, but at the end of the report, probably digest the two or dissect the two so that we know which ones are outstanding, which ones are not outstanding. That I think that's something that should be done. And that's why would just be for information, especially those that are closed. That's the first. But the second issue that I have, which I think that's where Semi would come in, Semi to really good work. It's because, like, I'll give you an example on the chieftaincy issue. Well, then you say they are not within a particular quarter for now, meaning they are not covered by any act that exists now. But now we go on and say the petition is awaiting adjudication. What is that we're going to adjudicate when there is no law that covers what they want? Because for months, if they are saying legally this cannot happen, why then are we going to adjudicate as a committee? That's what I'm saying. Probably we need to also do that so that sometimes we claim that we have got 50 petitions. In actual fact, we find that we only have 10. But because we want to make ourselves something that we are not, we end up with this heavy load of petitions. You know, because I don't understand where if say they are not falling within a particular quarter based on the chieftains, the policy does not cover them. Then we say still to adjudicate. What are you going to do? Because for me, that petition is closed. Because we are hit by certain impediments. It is when there will be new laws that will come in that they can re-establish or rewrite the petition. Because there are many that I've seen here, and all those things that we said we're going to do. There is one of Town Chabele which talks about a community hall that I think it has been wrongly referred, because it must be referred to Costa. That we are not a community hall. It's a tribal office. Yeah, tribal authority hall like it's one now. But yeah, in essence, Chair, I want to accept the report. It's safe to say that if we agree that where there are legal impediments for us to deal, or there are no legal provisions for us to assist members, we consider the petitions as being closed because we are hindered by legal provisions. Then we close those, and then we clean those petitions, and then there are only those that we can deal with. That will be my suggestion.
Maybe just Angela, these are actually the new petitions for consideration by the committee, and the committee must also give guidance on how we should then process that moving forward. So I'm not sure whether Dr. Fosa still wants to, on the issue raised by Honorable Konya.
No, I fully agree, Chairperson. Perhaps suffice to say that maybe we need to relook at those petitions and see which ones indeed will have to be considered as petitions that the committee will not have to deal with, and then maybe have a revised list of those petitions. I think maybe that is what was lacking, and perhaps, as you rightfully said, maybe we might have end up having even less petitions than they appear in the initial report, Chairperson. Maybe I think that is an exercise that needs to happen from our side as the committee support staff. Thank you.
Yeah, also just to say, Chairperson, most of these petitions, we bring them before the committee for consideration, for noting, and also for that guidance. It is for the first time that they come before the committee, and hence they are here for your guidance. Yeah.
In actual fact, they must come as they are, and the committee needs to give guidance.
No, sure. No. There are some that in the report say they are closed. So don't be choosy about them. Otherwise, you should be saying all of them are going to be adjudicated. But if you can have those that are closed, we are advising that even these ones, bring them here, say they are closed because of their nature. That's what we are saying. We agree with that all petitions must come here, irrespective of whether we have got jurisdiction or not. But what you write as status there, that's what we are talking about.
No, I agree with you. All what I'm saying is that all the petitions, they must all come to this committee. And this committee must consider them and give guidance on what must happen. That's exactly what I was saying. Yeah. So they don't have to be closed somewhere else.
No.
Yes. Yeah. So,
But just for interest's sake, let's accept that principle that they all come. And once they then have been dealt with at this level, they will then be processed somewhere in terms of the scope and application. The issue would then be that will that support staff really have that capacity in terms of that determination? And if that will not be the case, should we then also suggest that there be some form of level of Because if you look in terms of the presentation I said, from the previous one to this one, you then realize that there were certain cases that should then not have been dealt with because we don't have jurisdiction. So I'm just trying to check that 10%, so that they can also, as staff, relate to us that capacity that you need and are able to take. So that as and when we advise, we are also certain that at another level there will be proper prosecution of the advice that we have taken from this one. First.
Is there any other issue from members? Yeah, we are the list of I think where I think I like I've said, these petitions, all of them, they will then have to come, then have to look into them, consider them. And as and when they receive, as and when the petitions are received, they then look into them and classify them in terms of whether these ones is within the and they will also in terms of support staff, they will also guide the communities whether this one falls under our jurisdiction or not. I could not hear the other part that you said because I was disturbed by requesting for refusal. So but I think we have heard you. Okay.
Okay, Chair. Just to support what my colleague was indicating, I think what was lacking maybe is to check about the issues around the cost issues. If they are saying something is not within the law, that is something which we will analyze, because that is the only area where we've got challenges, because others were able to refer it to the correct entity, others were able to close, but the cost issues are the ones which we had a gray area on.
Can I then suggest that maybe in future, before they actually brought to us, you look into those areas so that you are also able also to you should also assist in guiding the committee when it has to make adjudication on those matters.
Especially those are related to motion. They're very sensitive. Everyone will come out and a rude head woman and whatever. Very much sensitive. Even this Cox, I guess, they will deal with that. I don't think we can just jump in and put us in a very.
I just wanted to say, so thank you. I just wanted to say the problem that we have is that, especially related to Magosha, they come to our offices and plead with us to say, please, Coxstar doesn't want to help us. We have gone to this one and this one, the municipality, they don't want to help us. Even the working House of Traditional Leaders, they don't want to help us. Please, take this, you are the last hope. As legislature, you are the last hope. Assist us. So I find that you can't just say, no, we can't take it.
You must find out if I am recognized as a traditional leader or not. Because some are claiming they are not. Most of them.
They are claiming. So
no, we understand that. We understand it's a very sensitive issue, like you are saying, caution. But at the same time, I think the group that we are suggesting to say it's important that because the relevant now department here is Coxstar, that must also try also to assist. But at the same time, we also have the challenge where the petitioner or the complainant start to say, I have lost the hope there, But ultimately, as and when, because this committee, as and when we have to advocate on those matters, we must make sure that we are correct, we actually, and administrators must have on that area so that when we start to engage on it now, we are sure in terms of the guidance that we have received properly from the administration side.
Or just to put Koshi at ease, I remember last year we dealt with one of those petitions of that nature, and then we received cooperation from Coxstar, and then the matter was properly resolved, and then it was dealt with accordingly.
Because part of our responsibility is to make sure that the petitioner or anybody, the complainants, we are actually trying to resolve this so ultimately, even we might not necessarily from time to time make everybody happy, but at least go halfway so that even the petitioner must understand that indeed the committee was very helpful in terms of addressing the issues raised by him. Yeah, I think it's almost 12. Advocate.
Thank you. Maybe just a short reflection, Chair. Thank you. I do understand what the honourable members are alluding to when they talk about, firstly, the earlier challenges of non-responsiveness, which I'm assuming was in the previous administration, the problem was showcased there. Was the issue of non-responsiveness. I just want to say that the Act is quite clear on what powers the committee will be having. So I think that can be covered. I think the council also agrees with that. But what I wanted to just bring to the House's attention is the issue of timelines. With the new petitions that were showcased here, it's always advisable that we also guard against the issues of timelines in the legal sense, because the people that the petitions from are normally they wouldn't know the legal intricacies of things. For instance, we have a petition where a group of individuals got scholarship from DST, for instance, and through the petition you can see that this is civil action, and the jurisdiction or the course of action would have been employed the responding being the department, which is the state government. We know that timelines now where prescription will then come to play, you have to give a notice for you to get proper redress. So I was just a bit concerned if, as the House, we have a mechanism to deal with those issues to avoid being party to whatever that may come later on. Another example, there's a gentleman who has a petition relating to non-payment of his chauffeur remuneration. We know that's a labor issue. During the presentation, it's unclear on what of employer-employee relationship was there, but one can assume that it might in any way be unfair labor practice. And there are timelines that are provided for by labor legislation. Wherein if we are sitting here as a committee and we receive that and it could have been avoided or dealt with upon inception, we find ourselves as a committee, I'm just saying, including myself, not necessarily the fact that I'm a committee member, but we find ourselves in a position where we can then decide if we get legal proceedings. So when future deliberations will be being held, something to consider would be the avoidance of possible litigation.
No, thank you very much, and I think I fully agree with you. All what also what we need to do. But as and when we receive this petition, it tells you a lot that as and when we have to go out and do public participation, we also have to do a lot of education to our citizens. That will also help us a lot because people will know, or citizens will know which matters should be referred to or what are their rights. Then it's important also just also to take other relevant stakeholders so that when we do that public participations programs, we involve the relevant other stakeholders that are key so that we could also give them a slot also to educate our people about something. But at the same time, I fully agree with you that if we are not careful, we might be cited if somebody has to decide to take a legal route. We might also have a way of constraining us financially. Yeah, I think basically that is that, and I'm not sure. I think we are done with 5.4. Can we go to item number 6, which is correspondences?
So, we don't have any correspondence for now, but what we can just for the ratification of the committee is the letter that we have written to Human Rights Commission, where we were forging this closer partnership with Human Rights Commission, so that when we go for our oversight, when we go for our public hearings and so on, mostly we'll be inviting them to join us. When we go for education outreach, we'll be inviting them to join us so that we consolidate on the execution of the legislature mandate. So that's the message.
Thank you very much. Let's go to an announcement item number 7.
Announcement that we have is that all attendees are invited for lunch. It's ready outside.
This brings us to item number 8, which is closure. Let me take this opportunity to thank honorable members and staff for honoring this invitation and your positive contributions